Good evening and welcome to Courts Today by LiveLaw. I am Urvashi Chauhan, and in this video we will talk about the Supreme Court's hearing on the release of Udaipur files, Isha Foundation's plea against a YouTuber, and the MP High Court's strong stand in a sexual harassment case. We will also cover key rulings on wrongful incarceration, a shocking missing kidney case, the Supreme Court's remarks on overreaching police probe, and a Delhi court's order against Unacademy for copyright violation. Watch till the end and make sure to subscribe and hit the bell icon. Starting with an update on the Supreme Court hearing on Udaipur files, a controversial movie based on the brutal 2022 killing of a tailor named Kanhaiya Lal in Udaipur. The hearing today before the bench of Justice Suryakant and Justice Joymalia Bagchi was adjourned because the central government was set to review the CBFC's clearance of the film later today. The court said that it will wait for centre's decision and posted the matter to next Monday, given the urgency raised by the filmmakers. The case here involves two petitions, one by an accused in the murder case who says that the film will affect his fair trial, and another by the producers who challenged a Delhi High Court order staying the release of the movie. The top court also addressed safety concerns raised by the film's makers and Kanhaiya Lal's son, who claimed that they were receiving death threats. The court also allowed them to approach the local police for protection. Senior advocates Kapil Sibal and Menika Guruswamy, appearing for the petitioners opposing the film, said that the movie spreads hate and could lead to violence. They also urged that it portrays the judiciary in a poor light and affects the rights of the accused. On the other hand, senior advocate Gaurav Bhatia for the filmmakers argued that once the CBFC certifies a film, its legality is presumed. He said that the Delhi High Court wrongly halted the release and that the film merely speaks against extremism, not any community. But the Supreme Court observed that under the Cinematograph Act, the union government has the power to decertify a film, so allowing a statutory revision before the centre was proper. The court said that balance of convenience currently favours the petitioners opposing the film, since releasing it now would make their challenges meaningless. On the other hand, the filmmakers could be compensated for any delay. While the Supreme Court will take up the case again next week, stay tuned. In a significant verdict, the Madhya Pradesh High Court has imposed a 5 lakh cost on the state government for delayed registration of a workplace sexual harassment complaint filed by a woman employee. She had accused the former Vice Chancellor of a national level physical education and yoga institute of sexually harassing her. The case goes back to 2019. The petitioner, appointed as a yoga instructor, alleged multiple instances of inappropriate behavior by the then VC, including inappropriate physical contact and demands for sexual favors. Despite raising complaints with the Department of Sports and other authorities, no action was taken. Her complaint was referred to the Internal Complaints Committee, but proceedings were delayed due to the COVID-19 pandemic. Eventually, the committee found the VC guilty, stating that his conduct was offensive to her dignity and unbecoming of a head of institution. Yet, no FIR was registered for over 3 years until the Supreme Court, on her special leave petition, finally ordered one to be filed under sections 354A, 509 and 120B of IPC, which pertain to sexual harassment, criminal conspiracy and insults to a woman's modesty. Criticizing the police for their inaction, the High Court said that police authorities are responsible for not taking action in time. They waited for 3 long years and were thus liable to be penalized. It has ordered the 5 lakh compensation to be recovered from the erring police officials personally. The court also directed the former VC to pay 35 lakhs to the woman as compensation for loss of salary, reputation, mental agony and emotional distress. Justice Milind Ramesh Phadke, who authored the judgment, held that the woman had indeed been subjected to sexual harassment and that the institute failed in ensuring timely and proper redressal of her complaint. The court noted that the institute's administration was controlled by someone not even fit to be kept in any service. The court also imposed 1 lakh penalty on the institute for failing to protect the complainant and delaying justice. It has directed that the woman may be transferred to another institution of her choice if she so wishes. The High Court cited landmark judgments like Lalita Kumari versus State of UP from 2014, which made it mandatory to register FIRs in cognizable offences, and Global Health Private Limited versus Local Complaints Committee from 2019, where cost was imposed on an organization for not having a functional internal complaints committee. In a powerful judgment with far-reaching consequences for criminal investigations across India, the Supreme Court has acquitted a death row convict in a 2021 double murder and rape case, citing serious lapses in the handling of DNA evidence. The court also issued binding guidelines for all states to ensure proper collection, preservation and processing of biological materials in criminal cases. In this case, Kattavilai or Devakar had been convicted for rape and murder of a woman and the murder of her husband in Tamil Nadu. Both the trial court and the High Court had sentenced him to death based mainly on DNA evidence that allegedly linked him to the crime scene. But when the case reached the Supreme Court, a bench of Justices Vikram Nath, Sanjay Karol and Sandeep Mehta found that the entire investigation had been compromised by serious procedural flaws, especially in how the DNA samples were collected, stored and processed. The court noted there was no proper chain of custody register, unexplained delays in sending samples to the forensic lab, and no clarity on how the samples were stored, leaving open the possibility of tampering or contamination. The bench observed that a common thread that could be seen to be running through the entire process was that of faulty investigation. As a result, the conviction was overturned and the accused was acquitted. Further, Justice Sanjay Karol, writing the judgment, laid down clear, binding guidelines on how DNA evidence must be handled moving forward. These include that there should be proper documentation during DNA collection, including FIR number, name of the investigating officer, date and designation of the medical professional present. DNA evidence must reach the forensic lab within 48 hours of collection. If not, a valid reason must be recorded in the case diary. DNA evidence packages cannot be reopened or resealed without permission from the trial court. And that a chain of custody register must be maintained right from collection to the final disposal of the case. The court also ordered the DGPs of all states to circulate sample forms and instructions to police stations and directed police academies to train officers on these new protocols. In so many cases, we see that the accused ends up spending years in jail, waiting for the case to be decided. And by the time the person is acquitted, a large part of their life has already been lost behind bars. You might have often wondered, does anyone get compensated for all the time spent in prison, especially if the person is later found innocent? Well, while delivering this important judgment, the bench said that India, unlike countries like United States, has no proper legal mechanism to compensate people who are wrongfully jailed even for decades. The court called the issue deeply connected to Article 21 of the Constitution, that is the right to life and personal liberty, and said that long-term wrongful incarceration amounts to a serious constitutional violation. The court clarified that it cannot frame laws. That's for the parliament to decide, but emphasized the urgent need to address this gap in the justice system. As you can see in this case, it was not a technical acquittal. It was a clean acquittal, meaning the man was entirely innocent. The police's poor investigation and lack of safeguards in handling DNA samples led to his wrongful conviction. The court has also pointed out that Law Commission's 277th report touched upon compensation for malicious prosecution, but did not fully address the broader issues of wrongful incarceration, and that the right to compensation must be recognized, especially in clear cases where someone is declared innocent after prolonged imprisonment. Well, do tell us about your views on this in the comment box. The Punjab and Haryana High Court has directed the Police Commissioner of Ludhiana to investigate serious allegations against a private hospital and its doctors in a shocking case of a missing kidney in a dead body. The case began in 2021 when the 22-year-old Tanya Sharma was admitted to HMC Hospital, Ludhiana for surgery. She underwent 2 operations, one on 2nd June and another on 7th June. But her condition deteriorated and she passed away on 16th June. The hospital listed cardiac arrest due to her being COVID positive as the cause of death. Being suspicious, her father filed a complaint and a post-mortem was conducted. The report revealed something disturbing. Her left kidney was missing. Yet, the medical report never mentioned it, and no expert analysis was ever carried out on this crucial detail. Well, now the High Court has said that this missing kidney is still a mystery, and prima facie, the report is silent on a vital issue. The court questioned as to why this was never investigated and whether any criminal act or organ theft was involved. It also noted that medical board failed to clarify if there was any medical negligence by the treating doctors. Calling it a matter of serious concern, the court has asked the Commissioner of Police Ludhiana to investigate the case without delay. It has allowed the constitution of a special investigation team and even the assistance of subject experts. Well, the case will now be heard again on 30th September. Stay tuned with LiveLaw. In another update, the Supreme Court today made strong remarks directed at the special investigation team set up by Haryana Police to probe Ashoka University professor Ali Khan Mahmudabad over 2 social media posts related to Operation Sindoor. The controversy began after the Ashoka University professor posted online commentary on the Operation Sindoor. FIRs were filed under sections 196, 152 and other provisions of Bharatiya Nyaya Sanhita against him related to communal harmony, national sovereignty and modesty of women. In May, the Supreme Court granted him interim bail while asking the Haryana DGP to form an SIT to understand the complexity of the expressions used in those posts. Today, senior advocate Kapil Sibal, appearing for Mahmudabad, informed the court that the professor was being repeatedly summoned, that his devices were seized and that questions were being asked about his travel history over the past 10 years. Something the court never authorized. A bench led by Justice Suryakant questioned as to why the SIT was expanding its scope far beyond the court's original directions. The SIT, the court said, was meant to examine just 2 specific posts and not dig into unrelated matters like professor's foreign trips or seize his devices without clear purpose. It reminded the state of Haryana of its own May 28th order, which had clearly stated that the SIT's investigation should focus only on the content and language of the posts and whether they attracted any criminal liability. Additional Solicitor General S.V. Raju, representing the state today, tried to defend the probe, saying that how to conduct the investigation was the prerogative of the investigating officer and that all incriminating aspects had to be examined. But Sibal countered this argument, saying that there cannot be a roving inquiry. He added that the petitioner had been summoned 4 times. The court recorded in its order that since the professor had already handed over his devices and cooperated with the probe, he should not be summoned again. It has directed the SIT to finish the investigation within 4 weeks now. The court also reiterated that interim bail conditions merely restrict Mahmudabad from commenting on the sub judice matter, but he is otherwise free to express his views on unrelated topics. Importantly, the court also questioned Haryana government about whether it had responded to National Human Rights Commission, which took cognizance of how the FIRs against Mahmudabad were registered. And lastly, Unacademy has been restrained by a Delhi court from using any copyrighted content belonging to news agency ANI, including videos published on its YouTube channel. The order was passed by Judge Himani Malhotra of the Patiala House Courts, who directed Unacademy to immediately remove all infringing content and prohibited it from publishing or uploading any similar content in future. ANI had filed a copyright infringement suit accusing Unacademy of unauthorized use of 3 videos originally created by the news agency. These were allegedly shared on the YouTube channel Pathfinder by Unacademy and distributed via its news feed, all without any license or permission. The court said that ANI had made out a prima facie case and added that not granting protection would result in irreplaceable harm to the agency. Google LLC, which runs YouTube, informed the court that the videos have already been taken down. But the judge has now directed Google to block or disable any such future content published by Unacademy if it infringes on ANI's rights. The court issued summons in the suit and listed the matter for hearing on 11th September.